Hi, everyone. Good evening. I hope everyone is doing well. I am Yael Brudner, immigration attorney here at Brudner Law, and I am coming to you guys live from our offices in Southern California. Um, we are an immigration law firm. We serve clients from all over the United States and around the world, helping them with their immigration needs. And today I'm here to answer your immigration questions. So if you're here and you're new, thank you so much. Please like our page and subscribe to our channel if you're watching on YouTube so that you can be informed about more events, more lives, and a lot more content about immigration. If you have any questions today, feel free to write them in the comments and I will get to them as we go. If I don't get to your question, I will respond later at a later time when I see it later. So if you are watching the recording of this, you can still ask your questions. Okay? Perfect. Everything I say today is just general information. It's not legal advice, okay? So if you have a specific question about your case and you want to get some legal advice, you can always call us and have a one-on-one consultation, okay? But today I have a bunch of really good questions that you guys sent us during the week. I picked the ones that I felt were the best questions. Well, all the questions are good, but the questions that I felt would be the most relevant to a lot of people. And again, if you're watching, please like, subscribe, and send me those questions. Okay, I'm gonna jump right in. Let's see. Okay, my husband filed a petition for me and I'm waiting for my case to be approved. Can I leave the US while I'm waiting? My brother is getting married in Italy. Well, congratulations to your brother. Well, this question is a very typical question. I am assuming that you filed for adjustment of status, so you filed for a green card in the United States, and you want to know if you can leave the US. And I really like that you're asking this question because it's always better to be cautious and ask if you can leave before you leave, right? So the answer to this question is you can leave, however, you do need to ask for permission first. Usually when we file for green card cases here in the United States, we usually generally always apply for something called advance parole. Filing for advance parole is a permission, filing for permission to travel while your case is pending without abandoning your green card case. So if you haven't yet filed for advance parole, you can. Right? You're eligible to file for advance parole. And if you filed for advance parole and you have not received it yet, then you can file for an expedited request to get your advance parole approved. Okay, it's important to remember you have to have a permission to travel before you leave the US. If you have a pending adjustment of status and you don't have any other visa that would qualify you to travel while you have an adjustment of status case pending, then you really do need to wait for that approval. Okay, so be very careful. You don't want your case to be denied or deemed abandoned if you travel without having permission. Okay, wonderful. Let's see. Oops, sorry about that. Okay. Michael has a question here on YouTube. Thank you so much for asking. I made a mistake on a citizenship question to get a bank account. Is that misrepresentation in the eyes of USCIS? Can you give me some more information about what exactly was the mistake that you made? You were trying to open a bank account and and you were asked a question about your citizenship status. Was that what happened? If you could give me a little bit more information, that would be great. And Gani is asking if you're a CSS class member. No, I'm not aware of that program. If you want to give me some more information about that, I can see if I can help you. Okay, Michael. So sometimes there are questions in different agencies that you go to, and they ask you, what is your status? What is your immigration status? Are you a resident? Are you a citizen? what is your status? So it's very important, if you're not a US citizen, not to indicate anywhere on any kind of documentation that you are a US citizen. Okay, if you got confused and you were mistaken and you didn't intend to do that, I would just go back and retract that statement. Okay, and ask to fix that that statement. Okay. Raquel is asking how long I-130 form approval takes. I-130 form, it really depends. If you've been following me for a while, you might know that the question how long something takes is really hard to answer because it really depends. The I-130 program, the I-130 petition can take anywhere from 8 months to 12 months. Okay, it really depends on what the category of the petition is. Um, and it depends. If the petition is of a category that is not current, then it can take even longer. Okay, Raquel? So if you can tell me a little bit about the petition, the I-130 petition. Who petitioned you? Or who are you petitioning? Gani is saying, yeah, late amnesty. Okay, yeah, I'm familiar with late amnesty. The program for the night from the 80s. Yes. I didn't realize it's CSS. But yes, I'm familiar with that. Did you have a specific question? And you're welcome, Michael. No problem. Perfect. For those of you guys joining us on Facebook or on YouTube, I am answering questions today, immigration questions. So if you do have any questions, feel free to write them in the comment and we can have a conversation here about your situation, and I can try to help as much as possible. Yeah, there were multiple programs in the 80s, amnesty programs, you know, different programs during that time. Okay. Let's see. While our viewers are kind of refraining their questions, I'm going to jump into another question, okay? I'm here as a student. I have a US citizen girlfriend. Can she petition me? Okay, so a girlfriend cannot petition you. So in order to have a marriage-based green card process, you guys would need to get married. Okay. Well, in order to get, let's reframe that. In order to get a green card through your relationship with your girlfriend, you would need to be married. So once you do get married and you have that marriage certificate, then you can pursue residency based on that green card, based on that marriage. Okay. So Raquel's asking 40, how long does a 45 adjustment of status takes for marriage of US citizen? So we're seeing really great processing times for adjustment of status 485s filed based on marriage to a US citizen. It really depends on where you're located in the US, but really, really good time. We've seen cases approved as early as 3 months, while some last a year or more. So like I said, it's really hard to tell with processing times, but it's right now a very good time to file. Okay, and it could be quick. Gani's asking, should I sign up for a consultation with you? I have a citizen wife and 2 adult daughters who can petition me. I would love to meet you for a consultation. You know, having a consultation with an immigration attorney really does give you that information that you need, the answers to your questions. You want to know if your wife or your daughters can petition you. Having a qualified relative is very important, right? That's the foundation of every green card petition, right? You need to have someone petition you. And then you also need to qualify for the green card. So I definitely recommend scheduling consultation with an attorney, having one-on-one time to really review your specific case and your situation, and for me to answer all of your questions. Okay, if you want to reach out to us, our number is right here on the screen, and we'd love to book a consultation for you. Okay, I hope I helped, and I hope to talk to you soon. There's a question here on YouTube. Have you had any cases that needed a vaccine waiver? What kind of vaccine? So, if you can give me more information, we've done vaccination waivers. The deal with waivers for vaccination is that there's two kinds of situations that could happen. And just as a background, anyone that's applying for residency here in the United States needs to go through a medical examination. Um, and part of the medical examination is to show that you have met all of the vaccination requirements. The COVID vaccine since October 2021 is now required in order to become a resident. There's two ways that you can become a resident without doing the COVID vaccination. The first one is that if there's any kind of medical reason why, and a doctor signs off and says that you cannot medically receive it, it's not recommended for you medically. Okay, if that's a situation, you don't need a waiver. Okay, if the doctor signs off and says medical reasons. If there's no medical reasons and you don't want to do the COVID vaccination and you want to ask for a waiver, you can file for a waiver. They're pretty hard, to be honest. You have to show that you are against all vaccinations and not just the COVID vaccination. You're just against vaccinations in general due to moral or religious reasons that have to do with your personal conscience. We have done those before. They are possible, but they're challenging, and they can take a while. They can take several months, so it can add several months to your case. But definitely, if you feel like you want to try, then you can definitely try for that waiver. I hope that helped. Gani's saying, I will only talk to you if that's possible. If you book a consultation with my firm, then you would be having a consultation with me, if that was your question, me personally. I would not be able to tell you if you have a case until we have our consultation, because there's a lot of questions that I would ask, especially for someone that's been in the United States for a long time. We have to do a thorough review of your history, your immigration history, to see if you meet the requirements for the green card. Blanca is asking about the religion exemption. Yes, if there is, if you are against a certain vaccination due to religious reasons, that could be the basis of your waiver request. So you would have the burden to demonstrate that for religious purposes, you are against vaccinations in general, not specifically the COVID vaccination, but just in general. Okay. So definitely, if you are looking to get a waiver, then I would consult with an attorney that will help you put together a good waiver. They're hard to get. They will delay your case, but they are possible. Okay. Okay. Can you fix your status if you came illegally to the country? So good question. Generally speaking, right, you could fix your status in the United States if you came in illegally, if you meet a certain exception. So if you go back, there is a law that says that in order to apply for the green card in the United States, you have to show that you've entered legally. Okay. If you cannot show that you entered legally, then generally speaking, you have to leave the United States for your process. Okay, leave and then come back legally as a resident. However, there are situations where you can fix your status, get a green card here in the United States, even if you did not enter legally. There's some exceptions to the rule. Okay, first of all, if you have anyone in the military, if you entered unlawfully once and you have someone in the military, an immediate relative, then you can apply for a special exemption of this rule through something called parole in place. Okay. If you have an old petition, so someone petitioned either you or your parents a long time ago, before 2001, and you were either included in this petition or you were eligible to be included in the petition, then you can apply for your green card here in the United States, even if you do not have a legal entry through something called 245I. Okay? If you were ever a victim of a crime in the United States, then you helped law enforcement by reporting this crime to the police, and it's one of the crimes that are a qualifying crime, then you can fix your status in the United States through the U visa. There is something called VAWA. So if you are in or have been in a relationship with a U.S. citizen spouse or lawful permanent resident spouse, or you have a child that's over 21 that has been cruel to you or abusive to you, and they're a U.S. citizen, then you can apply for something called VAWA, and this will allow you to self-petition for your green card in the United States without leaving. Okay, even if you came in unlawfully. If you're ever subject to labor trafficking or any kind of harsh conditions by an employer, or subject to domestic violence by a partner, you might be eligible for the T visa. Okay, so those are all examples of ways that you can fix your status in the United States, even if you came in illegally. Okay, so definitely, I couldn't, emphasize it more. Talk to an attorney if you think you're eligible, if you meet one of those requirements. Okay. Thank you to everyone that's joining. I'm Attorney Yael. I am answering immigration questions. So if you do have any questions, feel free to write them in the comments, and I'm going to try to get to all of them. Okay. Let's see. Lizzie is asking, I just got married. Congratulations. My husband is a green card holder, but next day he will apply for citizenship. Is it better to wait until the next day to present the documents, or can we present the form I-130 now? Well, congratulations, like I said. So you can file for your I-130 now. However, definitely I would recommend for your husband to file for naturalization if he is eligible, because right now the priority date for green card is not current, meaning there is a wait time for a petition based on a spouse that's a green card holder, that's a resident, as opposed to a petition by a U.S. citizen spouse where there's no wait time. There's processing times, but there's no specific amount of time that you need to wait before you can apply. I would definitely put in that I-130 petition and have it pending. And then once he becomes a U.S. citizen, then you can notify immigration to upgrade the petition and file something called an adjustment of status if you qualify for that. So yeah, I would file the I-130 right now. Okay, and then get that citizenship, and then upgrade that case. Okay. Okay, so Lizzie, you can't present both forms at the time. So you can't file for an adjustment of status yet. And I'm assuming that you're here in the United States, right? You're here? Okay, I'm assuming you're here. You can't file the adjustment of status application yet because the priority date is not current. So if he's a resident, then you need to file just the I-130 right now. At the same time, he can apply for his naturalization, for his citizenship. Yes, he can file for a petition for you, and he can file for his naturalization. Okay. Okay. Blanca is asking, how long is the parole in place take? Parole in place can take. How long is it processing times? It really depends on the service center, but we've been getting them around 3-4 months, and they last usually for 1 year. Okay, so within that 1 year, if you do have, you need to use the parole in place to be eligible to file for your case here in the United States. You need to do that in 1 year. Lizzie, you are here. Yeah, Lizzie, I would love to talk to you to explain the process a little bit more in detail, because it's hard to get into details and ask specific questions. But generally speaking, he can file for his naturalization, and you can file, and he can also file for you for the I-130 petition. Okay. Perfect. Holland is asking, going from Thailand to US, is K1 or K3 visa faster? Okay, so K1 and K3 are two different things. K1 is the fiance visa, and K3 is a visa that you can use while you're waiting for your I-130 to be approved, your petition to be approved, and to come to the United States while you're waiting. So for K1, it's fiance. You don't have to be married. For the K3, you do have to be married, and a marriage-based petition needs to be filed. If you ask what's faster, they're just different processes. Honestly, for Thailand, I would probably say I would do the marriage route, just because the fiance visas are taking almost the same amount of time as the marriage cases. So if you guys can get married, then I would probably do the marriage. But if you cannot get married anytime soon because you can't travel to see each other, I would probably do the fiance visa. But it really is personal. It depends on your circumstances. You're welcome, Lizzie, and you're welcome, Blanca. Thank you so much for asking questions and joining our show. Please subscribe to our page so you can get more information about immigration and jump onto our lives anytime. Okay, guys, I'm going to answer, I think, one or two more questions. Let me see. Here's one that we received. I just filed for my adjustment of status, but didn't turn in the medical letter. Will my case be denied? So there is a requirement to file with your case a medical examination. You have to submit that. It's part of the process. It's part of the admissibility requirements, right? To be admissible, to be eligible for the green card, you have to go to a doctor, and they have to submit a medical exam for you. If you did not turn it in with your adjustment of status, with your green card case, don't worry. What's going to happen is that immigration is going to send you what's called a request for evidence, and you'll be able to supplement it later. So your case will not be denied. Most likely what is going to happen is that you are going to get a request for evidence for the medical. But follow your case, okay? Make sure that if you move, that you update your address with immigration. I have seen it before when people moved and they didn't submit the medical, and they didn't get that letter telling them that they need to submit their medical, and then immigration just denied their case based on not submitting a medical. So you have to make sure you're following the case, you're checking online, you're seeing what the status is, okay? That is my advice. But usually if you're following the case, then you would be able to get a request for evidence and supplement the medical later. Okay. Let's see. My wife is filing a green card case for me, but she's unemployed. Can we use my income for the affidavit of support? So the intending immigrant, which is you, can use their income if you are working lawfully in the United States. So if you have a work permit and your income is from lawful employment, then yes, you can use your income for the affidavit of support requirement. However, if not, if you're working without a work permit, you cannot use that income. What you would need is a joint sponsor to go onto the petition with you. Okay. Okay, I had my citizenship interview and just received a notice of intent to deny my case. What does that mean? Do I have a chance? Okay. I know it's really scary when you get a letter that says notice of intent to deny, right? That does not sound good. It's not good. It means that immigration has a reason why they think you're not eligible for your citizenship. Usually it happens after the interview. They, instead of sending you an approval notice, they say, listen, something's not adding up. There's a reason why we think you're not eligible. And usually in the notice of intent to deny, they will lay out all the reasons why. It doesn't mean that you don't have a chance to get your case approved. The notice of intent to deny lets you or gives you the opportunity to respond and to rebut the allegations or the arguments that immigration is saying in their notice. I would not take this easily. I would definitely consult with an attorney for this kind of case because you really want to respond properly and strongly. And this is going to be your only and last chance to get your citizenship case approved, right? And we've seen a lot of notices of intent to deny that were approved. Okay, so definitely you have a chance, but you really want an attorney on your side to help you respond in the best way. Okay. Okay, I'm going to do one more question. Let me pick this one. Okay. How hard is it to get humanitarian parole? So humanitarian parole is an option to receive permission to enter the United States for humanitarian reasons. Usually it's for emergency reasons or for medical reasons or for reasons where someone is in a situation where they're unsafe and there's really an emergency. Like usually it's like life and death situation. Either someone in the outside of the United States or someone in the United States that someone wants to come and visit this person that is here in a very, very tough situation. It is hard to get humanitarian parole. It's challenging because really humanitarian parole kind of bypasses the whole visa process, right? If you want to enter the United States, you have to apply for a visa at the US Embassy and the consulate. And humanitarian parole basically says, I want to be able to enter without, disregarding the whole visa process. I don't want to wait for the visa, or maybe I know I'm not eligible for a visa. I just want to come in and receive this special permission. You can apply for humanitarian parole at the border. You can apply for humanitarian parole in advance with immigration before you come to the border. But generally speaking, those are hard to get. You really have a hard burden to show. Sorry. So if you feel like you're in a situation where you want to ask for humanitarian parole, meaning there's no other way that you can enter and you cannot apply for a visa for some reason, or you're not eligible for a visa, many times I tell my clients, let's try for humanitarian parole. Let's fight for it. Let's try for it. And we've been successful in the past, definitely, but those are not easy cases. Okay. Great, guys. Well, it was wonderful seeing everyone today. Thank you so much for jumping on to the live show today. I'll be back next week on Thursday, same day, same time, every Thursday at 5:30 Pacific. Please feel free to reach out through us, send us questions, like our page on Facebook, and subscribe to our channel on YouTube to get more immigration information. So until next week, have a wonderful day, wonderful evening, be safe and healthy.